Good day. We are now in our Rule 58 of the Rules of Court for the Provisional Remedies Preliminary Injunction. Again, I'm only reciting from the reviewer. So this is based on the contents as suggested in the 2020 bar examination syllabus. You can find this in bulletin number 9, and then this is in pages 8 to 9 of the said syllabus or bulletin. Okay, so this one is on preliminary injunction. So number 1, definitions and differences, preliminary injunction, temporary restraining order, and status quo ante order. It is an ancillary or preventive remedy where a court requires a person, a party, or even a court of tribunal either to refrain from, which is what we are referring to as prohibitory, or to perform, also referred to as mandatory, particular acts during the pendency of an action. It is merely a temporary remedy subject to the final disposition of the principal action. And this is from the case of Dungog versus Court of Appeals, GR number 139767, August 5, 2003. In the case of Republic versus Principalia Management and Personnel Consultants Incorporated, GR number 198426, September 2, 2015, the court said that as a rule, courts cannot enjoin an agency from performing an act within its prerogative, except when, in the exercise of its authority, it gravely abused or exceeded its jurisdiction. Administrative decisions on matters within the executive jurisdiction can be set aside on proof of grave abuse of discretion, fraud, or error of law, and in such cases, injunctions may be granted. Okay, so a preliminary injunction is an equitable remedy. A writ of preliminary injunction is an extraordinary event which must be granted only in the face of actual and existing substantial right. The duty of the court taking cognizance of a prayer for a writ of preliminary injunction is to determine whether the requisite necessary for the grant of an injunction are present in the case before it. In the absence of the same, and where facts are shown to be wanting in bringing the matter within the conditions for its issuance, the ancillary writ must be struck down for having been rendered in grave abuse of discretion. And so, in other words, that in granting a preliminary injunction, this is the court should be wary, or the court should be very vigilant as to granting this one. So this is in the case of Palm Tree Estates Incorporated et al. Versus Philippine National Bank, GR number 159370, October 3, 2012. Now, a petition for a preliminary injunction is an equitable remedy, and one who comes to claim for equity must do so with clean hands. This is now the same. This is the same case. Palm Tree Estates Incorporated and Bel Air Golf Country Club Incorporated versus PNB, GR number 159370, October 3, 2012. The action for injunction is distinct from the ancillary remedy of preliminary injunction, which cannot exist except only as part or an incident of an independent action or proceeding. Of course, the writ of preliminary injunction is a provisional remedy, but not the main action. As a matter of course, in an action for injunction, the auxiliary remedy or preliminary injunction whether prohibitory or mandatory, may issue. Under the present state of the law, the main action of injunction seeks a judgment embodying a final injunction, which is distinct from and should not be confused with the provisional remedy of preliminary injunction, the sole object of which is to preserve the status quo until the merits can be heard. In the case of Orbanes versus CA, GR number 117964, March 28, 2001. This means that the writ of preliminary injunction can be granted or can be issued in a main uh, cause or case where an injunction is sought. So in the action for injunction. But the two are distinct. Now, what are the purposes of preliminary injunction? The purpose of preliminary injunction is to preserve and protect certain rights and interests during the pendency of an action, such as all other provisional remedies. Its objective is to preserve the status quo until the merits of the case can be fully heard. In the case of Pineda versus CA 65 SCRA 275 and Castro versus De La Cruz 639 SCRA 187. It is to be restored to only when there is a pressing necessity to avoid injurious consequences, which cannot be remedied under any standard of compensation. The application of the writ rests upon an alleged existence of an emergency or of a special reason for such an order before the case can be regularly heard, and the essential conditions for granting such temporary injunctive relief are that the complaint alleges facts which appear to be sufficient to constitute a cause of action for injunction, and that on the entire showing from both sides, it appears, in view of all circumstances, that the injunction is reasonably necessary to protect the legal rights of plaintiff pending the litigation. In the case of Spouses Estares versus Court of Appeals, GR number 144755, June 8, 2005. So it is resorted where there is a pressing necessity to avoid injurious consequences. In other words, if there is none, then the writ of preliminary injunction cannot be granted. Now, status quo is the last actual, peaceable, and uncontested status which precedes a controversy. It is the situation existing at the time of the filing of the case. That is being said by the court in Preisler Jr. versus Court of Appeals, GR number 158141, July 11, 2006. Again, the status quo is the last actual, peaceable, and uncontested status which precedes a controversy. Now, in the granting of the writ of preliminary injunction, there should be showing of clear legal right. In the case of Executive Secretary versus Forerunner Multi Resources Incorporated, GR number 199324 on January 7, 2013, the court said that a preliminary injunctive writ under Rule 58 issues only upon a showing of the applicant's clear legal right being violated or under threat of violation by the defendant. The court said that clear legal right within the meaning of Rule 58 contemplates a right clearly founded in or granted by law. In other words, there are grounds that the grounds of clear legal right is founded in or granted by law. A preliminary injunction may be granted only when the plaintiff appears to be clearly entitled to the relief sought and has substantial interest in the right sought by the to be defended. While the existence of the right need not be conclusively established, it must be clear. Now, to distinguish preliminary injunction from temporary restraining order. The preliminary injunction is effective during the pendency of the action unless earlier dissolved. A TRO, according to Section 5, Rule 58, its duration is non-extendable. In other words, that the granting of preliminary injunction is effective or its efficacy can be had in the entirety of the pendency of the action unless earlier dissolved, while temporary restraining order is non-extendable and has a definite period. The trial court in preliminary injunction, the Court of Appeals, Sandigan Bayan, or the Court of Tax Appeals that issued a writ of preliminary injunction against a lower court, board, officer, or quasi-judicial agency shall decide the main case or petition within 6 months from the issuance of the writ as found in Section 5, Rule 58 as amended by AM number 07-0-12-SC. Now, in the TRO, it is if issued by the RETC or the MTC or the lower courts, it has a duration of 20 days from the service on the person sought to be enjoined. Now, if it is issued by the Court of Appeals, it has a duration of 60 days from service on the party sought to be enjoined, which is non-extendable. The 20 days actually in the lower court, if issued in the RTC or MTC, is also non-extendable. If issued by the Supreme Court, the TRO is effective until further orders of the Supreme Court. If the matter is of extreme urgency and the applicant will suffer grave injustice and irreparable injury, the judge may issue an ex parte TRO effective for 72 hours from issuance. So these are the differences of temporary restraining order from preliminary injunction. Now, to further elucidate temporary restraining order in Bacolod Water District versus Labayen, GR number 157494, December 10, 2004, the court said that TRO is an interlocutory order issued as a restraint to the defendant to preserve the status quo on the ground of irreparable injury and is granted to a party until the hearing of the application for preliminary injunction. A TRO is issued to preserve the status quo until the hearing of the application for a writ of preliminary injunction because the injunction cannot be issued ex parte. So the preliminary injunction cannot be issued ex parte, but the TRO can be issued ex parte. So this is now granted if there is an emergency or that will result to an irreparable injury to the plaintiff. The grant, denial, or lifting of restraining order does not in any way preempt the court's power to decide the issue in the main case. So the temporary restraining order cannot affect the decision of the court. That is what the Supreme Court said in DFA and BSP versus Falcon and BCA International Corporation, GR number 176657 on September 1, 2010. On the other hand, what is a status quo order? It is resorted to when the projected proceedings in the case made the conservation of the status quo desirable or essential, but the affected party neither sought such relief nor did the allegation in his pleading sufficiently make out a case for a TRO. This is a definition of the status quo order. Now, what is the difference between the TRO versus the status quo order? In Garcia versus Mojica, GR number 139043, September 10, 1999, the court said that TRO is heard in a summary hearing, while the status quo order is issued motu proprio on equitable considerations by the court. TRO prevents the doing of an act. The status quo order, because it is in the nature of a cease and desist order, since it neither directs the doing nor undoing of acts. TRO requires the posting of a bond unless exempted by the court as it is provided in the Rules of Court, Rule 58. But status quo order does not require the posting of a bond. So what are the requisites of the writ or for the application of the writ of preliminary injunction? Okay, for the issuance. A, the applicant must have a clear and unmistakable right. B, there is material and substantive invasion of such right. In other resources or in other books, this clear and unmistakable right is also called as right in esse. Now, letter C, there is an urgent need to issue the writ in order to prevent irreparable injury to the applicant. And D, no other ordinary, speedy, and adequate remedy exists to prevent the infliction of irreparable injury. And this can be found in the case of Ngo versus Allied Banking Corporation 632 SCRA 391, October 16, 2010. We have to consider also the doctrine of judicial stability in this provisional remedy. In the heirs of spouses Yadno versus the heirs of spouses Ancales or Anchales, GR number 174582 in October 11, 2012, the court said that no court has the power to interfere by injunction with the judgments or decrees of a court of concurrent or coordinate jurisdiction. A contrary rule would obviously lead to confusion and seriously hamper the administration of justice. Take note that these are courts of concurrent or coordinate jurisdiction only. So, an MTC cannot issue a writ of preliminary injunction to another MTC. Okay, so and vice versa, RTC to another TC. Okay. Now, what is the quantum of evidence required in a preliminary injunction? In Republic versus Evangelista, GR number 156015, August 11, 2005, the court elucidates that the quantum of evidence required for a preliminary injunction is a prima facie evidence. is needed to establish the applicant's rights or interest in the subject matter of the main action because the applicant is required to show only that he has an ostensible right or ostensible right to the final relief prayed for in his complaint. In another case of spouses Nietzsche versus Equitable PCI Bank, GR number 167434, February 19, 2007, findings of the trial court granting or denying a petition for a writ of preliminary injunction based on the evidence on record are merely provisional until after the trial of the merits of the case shall have been concluded. So in other words, even if there is no full showing of evidence, but if there is a prima facie evidence, clear and unmistakable right, thus the court can grant the writ of preliminary injunction. Now, who may grant preliminary injunction? Number 1, Supreme Court in its original and appellate jurisdiction. 2, Court of Appeals. 3, Trial Court in cases pending before it. 4, Sandigan Bayan. And 5, Court of Tax Appeal. And you can see that in Section 2, Rule 58. Again, what are the requisites of granting or application of or the issuance of the writ of preliminary injunction? Number 1, there must be a verified application stating the grounds for its issuance. 2, applicant must establish A, the existence of a right that must be protected or the right in esse. And 2, an urgent and paramount necessity for the writ to prevent serious damage. 3, applicant must establish that there is a need to restrain the commission or continuance of the acts complained of and, if not, enjoined would work injustice to the applicant. 4, applicant must post a bond unless exempted by the court. This bond is executed in favor of the person enjoined to answer for all damages which the latter may sustain by reason of injunction or restraining order. If the court should finally decide that the applicant was not entitled to the writ or order, and 5, notice and hearing is required. As a general rule, previous or prior and contemporaneous service of summons should be done. Exceptions that summons could not be served personally or by substituted service. B, adverse party is a resident but is temporarily absent from the Philippines. And C, adverse party is not a resident of the Philippines. Injunction against acts already consummated is also one consideration. As a general rule, no injunction against act already consummated can be granted who contemplates act being committed or about to be committed. In Romulo versus Iniguez, GR number 71908, February 4, 1986. But there is an exemption. If such acts complained of are continuing in nature and were in derogation of plaintiff's rights to the outset, preliminary mandatory injunction may be availed of to restore the parties to the status quo. So, acts already consummated cannot be prevented through the writ of preliminary injunction because it was already consummated. But it can because it cannot also be reversed, because the purpose of that is for the status quo, to preserve the status quo. It was settled that injunctive reliefs are preservative remedies for the protection of substantive rights and interests. Injunction is not a cause of action in itself, but merely a provisional remedy, an adjunct to a main suit. When the act sought to be enjoined has become fait accompli, the prayer for provisional remedy should be denied. So fait accompli meaning it's already consummated. The prayer for provisional remedy should be denied. Okay, this is in the case of Caneland Sugar Corporation versus Alon, GR number 142896, September 12, 2007. Because this is preservative remedy. In other words, it cannot be used to reverse, only to preserve. Okay, what are the requisites of mandatory injunction? We know that mandatory is injunction. Number one, there is material and substantial invasion of right. Number two, there is clear and unmistakable right of complainant, right in esse. Three, urgent and paramount necessity for a writ to prevent serious damages. In the case of Bautista versus Barcelona, GR number 1185, March 29, 1957. And four, the effect would not be to create a new relation between the parties. In the case of Alvaro versus Zapata, GR number L56025, November 25, 1982. So this is the uh, writ of mandatory injunction. What are the instances when mandatory injunction does not lie, or is not applicable, or cannot be granted? One is to compel cohabitation. In the case of Arroyo versus Vasquez in 1921. Two, cancellation of attachment. In the case of Lebe Hermanos versus Lacson in 1940. Three, release imported goods pending hearing before the Commissioner of Customs. In the case of Commissioner of Customs versus Cloribel in 1967. And four, to take property out of the possession or control of one party and place it into that of another whose title has not been clearly established in Pio versus Marcos in the 1974. So these are the instances when mandatory injunction does not lie. So we will go to number 3. What are the kinds of preliminary injunctions? So there are two. One is called the preliminary prohibitory injunction, and the other is preliminary mandatory injunction as found in Rule 58. So in prohibitory injunction is to prevent a person from the performance of an act, to prevent. In mandatory injunction, to require a person to perform a particular act. In preliminary prohibitory injunction, the act has not yet been performed, thus to prevent it. But in preliminary mandatory injunction, the act has already been performed and this act has violated the rights of another. In prohibitory injunction, status quo is preserved, while in mandatory injunction, status quo is restored. How about preliminary injunction versus final injunction? A preliminary injunction is an order granted at any stage of the action prior to the judgment or final order therein, as provided in Section 1, Rule 58. In Section 9, Rule 58, it is said there that final injunction is one issued in the judgment in the case permanently restraining the defendant or making the preliminary injunction permanent. So, the preliminary injunction becomes a final injunction when the court decides that it becomes permanent. Okay? So, this is the difference between the preliminary injunction versus final injunction. Now, what is the difference between the preliminary injunction versus the main action for injunction? Now, let us remember that preliminary injunction is a provisional remedy and thus is ancillary only to the main action. But there is a main action for injunction. And as we have seen from previous cases, preliminary injunction can be applied for uh, if there is a main action for injunction also. So, preliminary injunction as an ancillary remedy, it is provisional. It is not the cause of action itself but merely an adjunct to the main cause. While in the main action for injunction, it is independent and it is a primary action. In the preliminary injunction, it seeks to preserve the status quo until the merits can be heard. While the action for injunction, main action, it now perpetually restrains or commands the performance of an act after the trial. Again, these are the types of injunctions and what is the difference between the prohibitory injunction versus prohibition. So, prohibitory injunction is a provisional remedy as found in Rule 58, while prohibition is a special civil action found in Rule 65. Prohibitory injunction is directed against a party litigant in the action or the main action, while in prohibition, it is directed against a court, tribunal, or person exercising judicial power. In prohibitory injunction, it does not have or it does not involve the jurisdiction of the court, but in prohibition, it may be on the ground that court against whom the writ is sought acted without or in excess of jurisdiction. Okay. What is the difference between mandatory injunction versus mandamus? So, mandatory injunction, again, is a provisional remedy found in Rule 58. And mandamus, again, is a special civil action found in Rule 65. Mandatory injunction is directed to a party litigant to perform an act to restore the last peaceable and contested status preceding the controversy or the status quo. While in mandamus, it seeks a judgment commanding a tribunal, corporation, board of officer, or person to perform a ministerial duty required to be performed by law as provided in Section 3 of Rule 65. Take note that this is to perform a ministerial duty required to be performed by law or certain laws. So let us go to when writ may be issued and when writ may not be issued. So a preliminary injunction or a TRO may be granted only when Number one, the application and the action or proceeding is verified. There is a verified affidavit or there is a verified application and shows facts entitling the applicant to the relief demanded. Unless exempted by the court, the applicant files with the court where the action or proceeding is pending a bond executed to the party or person enjoined in an amount to be fixed by the court. Unless exempted, in other words, the court has the discretion to set said bond. That is in Section 4, Rule 58. Number 3, when an application for a writ of preliminary injunction or a TRO is included in a complaint or any initiatory pleading, the case, if filed in a multiple sala court, shall be raffled only after notice and be enjoined. In any event, such notice shall be preceded or contemporaneously accompanied by service of summons together with a copy of the complaint or initiatory pleading and the applicant's affidavit and bond upon the adverse party in the Philippines. In the multiple sala court, the uh, executive judge can uh, issue TRO uh, with a 72-hour duration, and he will have to pass it on to a certain, he will have to raffle it with a notice to the uh, persons or defendants enjoined. And then the presiding judge where the case has been assigned will have to determine or to decide if the TRO can be extended and a preliminary injunction can be granted. Okay, so that is the process. However, where the summons could not be served personally or be substituted service despite diligent efforts, take note that despite diligent efforts or the adverse party is a resident of the Philippines temporarily absent therefrom or is a non-resident thereof, the requirement of a prior or contemporaneous service of summons shall not apply. This is the exemption to the service of summons. 1. The application for a TRO shall thereafter be acted upon only after all parties are heard in a summary hearing. So the hearing is a summary hearing, which shall be conducted within 24 hours after the sheriff's return of service and or the records are received by the branch selected by raffle and to which the record shall be transmitted immediately. So the TRO has a duration of 72 hours, but the summary hearing shall be conducted within 24 hours after the sheriff's return of service. Okay, so that is should also fall within the 72-hour period. So, contemporaneous service of summons in preliminary injunction. As a general rule, again, the enforcement of a writ of preliminary injunction must be preceded by or simultaneously accompanied by service of summons, copy of complaint, application, and affidavits for the preliminary injunction, and the bond upon the adverse party. So, prior and contemporaneous service of summons. Except, so exception, where the summons could not be served personally or by substituted service despite diligent efforts, or the adverse party is a resident of the Philippines temporarily absent therefrom or is a non-resident thereof, the requirement of prior contemporaneous service of summons shall not apply as found or provided in Section 4, paragraph C of Rule 58. How about ex parte writ of preliminary injunction? No preliminary injunction shall be granted without hearing and prior notice to the party or person sought to be enjoined. It is very clear in the law. The reason is that a preliminary injunction may cause grave and irreparable injury to the party enjoined. There is no preliminary injunction if the party or person sought to be enjoined is not granted with hearing and prior notice. Now, if it shall appear from facts shown by affidavits or by the verified application that great or irreparable injury would result to the applicant before the matter can be heard on notice, meaning the writ of preliminary injunction, the court may issue ex parte a TRO. So this is now the difference between the writ of preliminary injunction and a TRO. TRO can be issued ex parte with the limitation of 72 hours, and it can be extended for 20 days, including the 72 hours. But the writ of preliminary injunction cannot be granted without hearing and prior notice to the party or person sought to be enjoined. If the matter is of extreme urgency and the applicant will suffer grave injustice and irreparable injury, the executive judge of a multiple sala court or the presiding judge of a single sala court may issue ex parte a temporary restraining order effective for only 72 hours from issuance, but he shall immediately comply with the provisions as to the service of summons and the documents to be served therewith. Thereafter, within the aforesaid 72 hours, the judge before whom the case is pending shall conduct a summary hearing to determine whether the temporary restraining order shall be extended until the application for preliminary injunction can be heard. In no case shall the total period of effectivity of the temporary restraining order exceed 20 days, including the original 72 hours provided therein. This is a provision taken from the rules. In the event that the application for preliminary injunction is denied or not resolved within the said period, the temporary restraining order is deemed automatically vacated. Now take note that trial court cannot issue a writ of preliminary injunction based solely on the applicant's evidence. The trial court commits grave abuse of discretion when it issues such writ prior to the termination of the presentation of evidence by the party against whom the injunction shall be issued. The order to show cause why the injunction should not be granted is stated in Section 5, Rule 58 of the Rules of Court, is precisely directed to such party, not on the injunction's applicant. In other words, that the defendant or the one to whom the injunction is to be applied must also show their evidence why the writ be granted. Now, this is found in the case of Lee versus CAGR number 147191, July 27, 2016. When does what instances when a writ of preliminary injunction may be issued? Okay, so in this list, number 1, in petitions for relief from judgment entered through fraud, accident, mistake, or excusable negligence or fame. 2, in petitions for certiorari, prohibition, and mandamus. In other words, in the main action for certiorari, prohibition, and mandamus, you can now uh, apply for the writ of preliminary injunction. Number 3, in actions for annulment of judgments obtained through fraud. Now remember that in a concurrent courts, you cannot apply this one. Only if you go to the higher courts so that this may be applied. Number 4, in actions for annulment of judgment which is or which are not patent nullity. That is, there is no want of jurisdiction or lack of due process of law, or there is want of jurisdiction or lack of due process of law. In the case of Banco Espanyol versus Palanca, 37 Phil 921. What else? To restrain continued breach of valid negative obligation. Again, to enjoin repeated trespass on land. What else? To restrain city from proceeding with abatement of nuisance per accidents before it has been judicially declared as such. To restrain voting of disputed shares of stocks, and to restrain sheriff from selling property on execution not belonging to judgment debtor. A writ of preliminary mandatory injunction will not be set aside unless it was issued with great abuse of discretion. That is in the case of George C. versus Autobus Transport System, GR number 176898, December 3, 2012. So, what are the consideration in the issuance of writ of injunction to enjoin criminal prosecution? As a general rule, public interest requires that criminal acts be immediately investigated and prosecuted for the protection of society. With the exception that to afford adequate protection to the constitutional rights of the accused. Okay, in Hernandez versus Albano, GR number L1927, January 25, 1967, and when necessary for the orderly administration of justice or to avoid oppression or multiplicity of action. In Di Mayuga et al. Versus Fernandez, in Hernandez versus Albano, again, in Fortune versus Labang, 1981. What else? When there is a prejudicial question which is sub judice, in De Leon versus Mabana, and when the acts of the officers are without or in excess of authority, Planas versus Hill, where the execution is under an invalid law, ordinance, or regulation, Yang versus Rafferty, Yu Kong Eng versus Trinidad, or when double jeopardy is clearly apparent, Sanggalang versus People and Avendia. Okay? So, issuance of writ of injunction to enjoin criminal prosecution. So, these are cases where, or these are instances where the uh, defendant or the accused can file or can apply for the writ of injunction to enjoin that criminal prosecution. What else? Where the court has no jurisdiction over the offense. Where there is a case of persecution rather than prosecution. Where the charges are manifestly false and motivated by the lust for vengeance. When there is clear no prima facie case against the accused and a motion to quash on the ground has been denied. And preliminary injunction has been issued by the Supreme Court to prevent the threatened unlawful arrest of petitioners. Again, what is the second application for preliminary injunction? A second application for injunction, which rests in the sound discretion of the court, will ordinarily be denied unless it is based on facts unknown at the time of the first application. In other words, the the applicants can apply for a second time for preliminary injunction if unless it is based on facts unknown at the time of the first application, or it can be granted if from the first there was the grounds was unknown in the first, or there are subsequent grounds in the intervening period. Now, this is found in the case of Reyes versus the Court of Appeals and Sun Life Insurance Office Limited, GR number 87647, May 21, 1990. What are the actions or where preliminary injunction will not lie? First, against Department of Public Works and Highways to stop government infrastructure projects. Now, preliminary injunction cannot be granted, cannot lie against Department of Public Works and Highways to stop government infrastructure projects. It is found in Section 3 and 4, RA 8975 and PD 1818, except when there is extreme urgency. B. Matter involves a constitutional issue. C. Grave injustice and irreparable injury will arise. And D. Supreme Court may issue the writ of preliminary injunction. Now, only the Supreme Court may issue injunction against the government, officials, or any person or entity where public or private acting under the government direction to restrain, prohibit, or compel acts pursuant to the implementation and completion of infrastructure projects. Section 3 of RA 8975. Acts perpetrated outside the inferior court's territorial jurisdictions against judgments of coordinate courts and quasi-judicial bodies of equal rank. Issues will effectively dispose of the main case without trial and or due process. In cases of labor disputes, in issuance of licenses, concessions as to disposition, exploitation, utilization, exploration, and or development of natural resources. Section 1 of PD 605. Implementation of Comprehensive Agrarian Reform Program, collection of taxes, and criminal prosecutions unless it is found in the exemptions also on the use of preliminary injunction to prevent criminal prosecution. Mandatory foreclosure of a mortgage by government financial institution, except after hearing, it is established that 20% of the outstanding rearges is paid after the filing of the foreclosure proceedings. Acts sought to be enjoined already consummated, except acts which are continuing in nature and were in derogation of plaintiff's rights at the outset. Preliminary mandatory injunction may be availed of to restore the parties to the status quo, to transfer the property in litigation from the possession of one party to another where the legal title is in dispute and the party having possession asserts ownership thereto, except forcible entry and unlawful detainer cases. Preliminary mandatory injunction may be issued. Generally, injunction will not be granted to take property out of the possession of one party and place it in another whose title is not clearly established, when action for damages would adequately compensate injuries caused, to prevent directors from discharging their offices and restoring former directors, and to restrain criminal prosecution where the Ombudsman had authorized the special prosecutor to conduct a preliminary investigation or to file an injunction. Generally, again, injunction does not lie to restrain the enforcement of a law alleged to be unconstitutional except if it will result in injury to rights in private property, to restrain collection of taxes, except there are special circumstances that bear the existence of irreparable injury. What are the grounds for issuance of preliminary injunction? One, that the applicant is entitled to the relief demanded and the whole of or part of such relief consists in restraining the commission or continuance of the acts complained of or in requiring the performance of an act or acts either for a limited period of time. Two, that the commission, continuance, or non-performance of the act or acts complained of during the litigation would probably work injustice to the applicant. Or three, that a party, court, agency, or a person is doing, threatening, or is attempting to do, or is procuring or suffering to be done some act or acts probably in violation of the rights of the applicant, respecting the subject of the action or proceeding, and tending to render the judgment ineffectual. Requisites of preliminary injunction, whether mandatory or prohibitory injunction, is that the applicants must have a clear and unmistakable right, that is, a right in ease or ease. Two, there is a material and substantial violation of that right. Three, there is an urgent need to the writ to prevent irreparable injury to the applicant. And four, no other ordinary, speedy, and adequate remedy exists to prevent the infliction of irreparable injury, as in the case of Marquez versus Sanchez, 515-577. What are the grounds for objection to or for the dissolution of injunction or restraining order? The party enjoined may file a motion to dissolve the injunction or TRO with notice and hearing of the motion upon showing by affidavits that the person enjoined would suffer irreparable damage, while the applicant can be fully compensated for such damages as he may suffer. The movant must also file a bond conditioned upon the payment of all damages which the applicant may suffer by the dissolution of the injunction or restraining order, as provided in Section 6, Rule 58. So what are the grounds for objections or dissolution of injunction or restraining order? One, insufficiency of application for injunction or restraining order. The application may be considered insufficient if it is not verified and supported by any of the grounds under Section 3, Rule 58. Two, issuance or continuance of injunction or restraining order causes irreparable injury, while applicant may be fully compensated for damages by the bond filed by the person sought to be enjoined. Three, extent of jurisdiction or restraining order is too great. Effect, modification, Section 6, Rule 58. Or for insufficient or defective ban, as found in Section 7, Rule 58. Filing of verified motion and ban as well as hearing is required. Number 7, duration of temporary restraining orders. The duration of TRO issued by the courts, when available, if great or irreparable injury would result to the applicant before the matter can be heard on notice, the court may issue ex parte a TRO effective only for 20 days from the service of the party sought to be enjoined. If granted or issued by the executive judge or the presiding judge, if the matter is of extreme urgency and the applicant will suffer great injustice and irreparable injury, 1. TRO effective only for 72 hours from issuance, and 2. Its effectivity may be extended after conducting a summary hearing within 72-hour period until the application for preliminary injunction can be heard. If issued in the CA or any of its member, effective 60 days from service on the party sought to be enjoined. if issued by the Supreme Court or any of its members, effective until further orders. The period of 20 days is non-extendable. The rule against a non-extendibility of the 20-day effectivity of a TRO is absolute if issued by RTC. The failure of the trial court to fix the period in the TRO does not convert it to a preliminary injunction, as in the case of Bacolod City versus Labayan, GR number 157494, December 10, 2004. What are the duty, or what is the duty of the court within the 20-day period of the TRO? Number one, the court must order said party or persons to show cause why the injunction should not be granted. One, so within the same period, the court shall determine whether or not the preliminary injunction shall be granted and then issue the corresponding order, as in the case of Australian Professional Incorporated versus Municipality of Padre Garcia, GR number 183367, March 14, 2012. As a rule, the writ of prohibition will not lie to enjoin acts already done. However, as an exemption to the rule on mootness, courts will decide a question otherwise moot if it is capable of repetition yet evading review. And lastly, number 8, rule on prior or contemporaneous service of summons in relation to attachment. As a general rule, just as in levy on preliminary attachment, there must be proof of prior or contemporaneous service of summons with a copy of the complaint or initiatory pleading and applicant's affidavit and bond on the adverse party, except when summons could not be served upon the defendant either in person or by substituted service despite diligent efforts, or when the defendant is temporarily out of the Philippines, or when he is a non-resident of the prior contemporaneous service.